Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. Arbitration agreements. They're an important tool for employers due to the relative speed and lower cost associated. However, arbitration agreements are subject to increasing scrutiny and require careful consideration from employers. Epstein Becker Green's Victoria Sloan Lynn highlights some of the hidden elements that can impact cost.
Arbitration, just like anything else, has costs associated with it. When you're drafting your arbitration agreement, you're going to want to give yourself some flexibility. For example, you could provide that a particular arbitration have one versus a panel of 3 arbitrators. In addition, you want to allow yourself the use of all the rules available of a particular forum. If that forum provides for expedited or simplified arbitration, that may help with the cost of the arbitration, limit discovery, and shorten the time period which the arbitration would take place.
Class and collective action waivers can be another unexpected source of complication. While there are clearly benefits to avoiding these actions, there are some trade-offs employers should consider.
If dozens or more arbitrations are filed at the same time, each will have its own discovery and its own arbitrator or panel of arbitrators, which has time, costs, and effort associated with it. In addition, there's the potential for inconsistent orders and awards, which may impact the implementation of your policies and procedures going forward.
Epstein Becker Green's Andrew Lichtenstein points out that it's important to pay attention to the structure and execution of these agreements, as increasingly challenges to these agreements are trending towards attacks on formation.
Now what we're starting to see are arguments that relate to more the formation of the arbitration agreement. So the plaintiff will claim, that I didn't understand the agreement when I signed it, or even that I never really signed it, or I don't remember signing it. The onus is put on the employer to prove with evidence that the employee, in fact, did agree to the arbitration agreement and did sign it. And we are seeing much more arguments about the formation requirement. Another thing that we've seen is employees saying that arbitration agreements are illusory. That really, as a formalistic matter, that's really an attack against the consideration requirement. So all contracts 101 will tell you require an offer, acceptance, and consideration. The argument that an agreement is illusory really means that, it's not really binding on one party, or there isn't this exchange of consideration.
Thanks, Victoria and Andrew. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.